Mamta.
Hi, ma'am. Ma'am, can you hear me?
Yeah, I can hear you.
Yes, ma'am. How are you, ma'am?
I'm good. Okay, Surya, is it your first class or you were there before also?
I'm starting my classes from today. Yesterday I did
Today.
my CRPC first class.
Okay.
Today is the first class of your session.
Okay. So we have completed few of the parts of Indian Contract Act. So today you can attend the remaining part. Okay, so yeah.
Good evening, ma'am.
Good evening. Okay, so today we'll start with the performance part, okay, performance of contract, and then one more portion is remaining from the general provisions. Then we will move with the specific contract. So Mansi, your case also we will discuss on the last class, okay, when we complete this general provisions part, that day only we will discuss that also. Okay, so today we'll start with performance of contract. But before that, so what happens is that when a contract is formed, right, we are under some kind of an obligation, right? Both the parties are under an obligation and they should perform their contractual obligations. Once it is performed, then we can say that, okay, fine, this contract has been discharged, you know, like obligations both the parties have performed. Now it's done and everything is settled between the parties. So how contract can be discharged, right? So modes of discharge of a contract. So two parties are there. They both like made one promise, another one accepted the promise. They both entered into the contract. Now, how they will discharge the contract? There will be certain responsibilities of both the parties, right? So how they will discharge that particular contract? So it can be done by various ways, okay? So these are the different modes of discharging a contract that we will see. So there are different ways how parties can discharge their contract. So one person is bound under certain obligations under a contract, how he can discharge his obligations or his responsibilities. So the first way that we have is by performing. So how we can discharge our obligations? If I am under some kind of an obligation, maybe to supply certain goods or maybe to provide certain kind of a service, I can discharge my contract by performing that. Maybe I can supply those materials, I can supply those goods, or maybe I can provide that particular service. So first thing that we have is by performance, that we both have performed our obligations and the contract is being discharged. Secondly, it may be by mutual agreement also. So what is mutual agreement? That both the parties decide on the matter. It may be that, take for example, there is a conflict between two persons. They both decide to make some changes in the contract and form a new contract. So in that case also, the previous contract they don't need to perform, right? We can say that the previous contract has been discharged. They don't need to perform it. They may make certain alterations or certain changes in that particular thing, or they may cancel that particular contract altogether and form a new one. So it may be by mutual agreement also, where both the parties would decide that, okay, fine, we want to bring these changes, or maybe we want to make a new contract. So the previous contract or previous obligations need not be performed. We can say that it's also been discharged, right? This contract has also been discharged. Next, maybe by operation of law. What can be operation of law? Anyone? How by operation of law contract can be discharged? So operation of law, as in law would come into picture and it would take, like play its role. Take for example, like there is a contract between two persons, one of the party dies. What will happen in case of death of one of the parties? Will their legal representatives be responsible or not? That thing who will decide? Court would decide. Maybe there is like one company is there, it made one contract with another company. Later on, this company merged with another company. Now, who will perform? In case of insolvency, who will perform? That particular company is no more financially capable of performing its obligations. So, in all those things, we can say that by operation of law. So, law would decide, courts would decide whether legal representatives would perform, or whether we would say that, like the contract is void, impossible to perform, or what would happen in that case. And last is impossibility of performance, that the contract becomes impossible. It may be because the contract itself was a void agreement, or maybe because one of the parties died, maybe because there are certain changes in the law and we cannot perform it, or maybe there may be certain other reasons also. So how contract can be discharged? It may be by performance, that whatever is the thing, I performed it, so I'm discharged from my obligations. It may be by mutual agreement. Both the parties decide that, okay, fine, we want to make these changes. So accordingly, the previous clauses, they don't need to perform. The previous contract, they don't need to perform. It may be by operation of law. It would apply in case two companies merge together and form one company. So those things you would anyways get in specific relief act also. What will happen in case two companies merge together without completing their previous contractual obligations? So the new company will have to perform those obligations. Or it may be because of impossibility of performance. When contract itself is not possible to be performed, then also we can say that it has been discharged, right? That the parties are no more in a position to perform their obligations. So accordingly, we would say that this contract is being discharged. So this is like in general, okay? What will happen in case there is a contract? It's like a promise made between the two parties. When contract would be completed only when those promises are being performed. If I am saying something that I would perform this thing, I would provide this service, I should do it, then it would become complete. But in certain cases, it may be by other ways also that the contract may be performed or contract may be discharged. So is this part clear? What are the four different things, like modes of discharging contractual obligations? See, today we will be discussing this thing, okay? Performance and the mutual agreement thing, and operation of law and all. You can say, take for example, insolvency. You can take an example. Insolvency. There is one company A. It made an agreement. It made an agreement with another company B. Later on, what happens is that under Insolvency and Bankruptcy Act, this company was declared as insolvent. It's no more financially capable to maybe repay the loans or something like that. So in that case, court would come into picture. Whatever like property or anything that this company is having, which that they, like it may be distributed to all the people, all the creditors or something like that. So that would be a case where operation of law, we will discharge the contract. It may be by way of it may be when a new company is formed. new company is formed or a new partnership is formed. So already there were certain contractual obligations that were not fulfilled, right? That were pending. So this new company that is formed by merging two or more companies, this new company will have to complete all those contractual obligations. So like that, it may be operation of law, or it may be impossibility of performance. If one of the parties to the contract dies, their legal representatives, if they are not responsible to perform their part of contract, then also we can say that this is discharged because of impossibility of performance. One of the parties died, so we cannot proceed with this particular agreement. So is this part clear? What is discharge of contract? Discharge as in when we will say that this party is free from their responsibilities, right? So what is contract? Take for example, there is a contract between A and B. So both A and B are responsible, right? They are under some kind of an obligation to fulfill their contractual obligations. So what is discharge of contract? Making them free from their obligations, right? So if there is A and B, two parties to the contract, when we set them free from their obligations, we can say that this contract has been discharged. So what are the different modes or different ways of discharging a contract? Obviously it would be performance, then it may be mutual agreement. Two parties decided, okay fine, we don't want this thing to be done in this way, maybe it should be done in another way. That means they are making some changes in their contract. There may be, like forming a new contract altogether. They might say that, okay fine, this is not what we want this thing only. So they are making some changes in the contract. It may be between the parties, right? They both decide that not this way, but this way we want the obligations to be performed. So in that case also previous things need not be performed. It may be by operation of law like insolvency, like merger and all of that. It may be by impossibility of performance. Parties died because some new laws came or certain changes were made to the existing laws. Now it's not possible for the parties to perform their part of contract. So this is how contract can be discharged, right? We can make the parties free from their obligations. These are the four different ways that we have by which we can make the parties free from their contractual obligations. So is this part clear? What are the modes of discharging a contract? Is it clear? Any doubts, anyone?
No, ma'am.
So discharging a contract doesn't, you can just remember that there would be different parties to a contract. We will make them free from their obligation. So how we can say that they are free from this particular obligation or promise that they made? It may be that they performed it, they already completed their promise. It may be by mutual agreement. Both the parties decided that maybe we don't want to proceed with this particular service or particular purchase, sale or other things. It may be by operation of law. The court would say that this is how it should be done or this is how you should settle the matter. Or it may be by way of impossibility of performance, that later on it became impossible for the parties to perform their part. So chapter 4, right? Chapter 4 of Indian Contract Act talks about performance of contract. So Indian Contract Act is having different chapters, right? So we discussed the first 3 chapters. Now it is about performance of contract, how contracts or contractual obligations can be performed. Again, there are like a lot of sections, okay? Sections 47 to 70 is like 67. All those sections are not important, but you can remember the important sections. So today we will be discussing some of the important sections. That part you can remember. Take for example, who is under an obligation to perform a contract? So those sections you can remember because those would be the ones that are very important. So this chapter, right, chapter 4 regarding performance of contract, it basically talks about 6 different things. So these are the 6 different things that this chapter talks about. Firstly, which all different types of contracts are to be performed, right? Contract which must be performed, what type of contracts we should perform, who should perform a contract, time and place where it should be performed, performance of reciprocal promises, appropriation of payment, and contracts which did not be performed. So these are the 6 different things that we will look into today. So first is contracts which must be performed. Now see, we all know, right, when there is a contract between like 2 or more parties, they are bound to perform it, right? So this provision is saying contracts which must be performed, as in what all contracts should be performed. So this provision is mentioned under sections 37 to 39. So whenever there is a promise or there is a contract, right? Take for example, there is a contract between A and B. Take for example, there is a contract between A and B. So there is a contract between A and B. Now it's implied that they both should perform their contractual obligations, right? Because they have made that particular promise. Now they both are under an obligation to perform their part of the contract or their part of promise. So in which all cases they are not supposed to perform it, and they are supposed to perform it unless it is dispensed with or excused under some kind of a law or some kind of provision under the Indian Contract Act. So there may be 2 situations where we don't need to perform a particular contract. First is when maybe something I promised, later on it's no more necessary. In that case, I will be excused. I don't need to perform it. Or secondly, under the Indian Contract Act or under some other laws, I'm no more, like liable to perform it. I'm excused under that particular law, and so I will not perform it. So what is this provision basically telling us? That in all the other cases, we should perform or we should complete our obligations. Only there are 2 situations or 2 things when we don't need to perform it. When we don't need to perform it, when it's no more necessary, right? Dispensed with. When it's no more necessary, then we don't need to perform it. Or under some laws or under Indian Contract Act, if the parties are excused, in that case also we don't need to perform it. So first one is, take for example, like there is one person who is like a broker, okay? He just helps people to get permissions or approvals from government departments, okay? There will be different brokers, right? In RTO offices and all also you would see. If you go to take your driving license or RC or permit or anything like that, there will be these brokers who would help you get the documents from the department, right? So take for example, A is also such kind of a broker. And what he does is that he helps prospective businessmen to get permission from department to establish different factories, okay? So for establishment of factories also, we would need different types of permissions, right? That we are fulfilling all the environment related laws, guidelines, and all of that. So this person is there who helps people get permission or approval from government. Now take for example, it's needed that we should take NOC from the local people, right? From the community, we should take one NOC. From municipal body like BMC and all, we should take one approval, and then only we can apply for permission. Later on, if there are some changes in the guidelines that we don't need to take approval from municipalities, then what happens? This broker is no more responsible to take NOC from the community or municipal approval from municipality. Why? Because it's no more necessary to get permission for that establishment of factory. So this first thing is saying that when it's no more necessary to perform it. First of all, take for example, I am a broker. First of all, I promise that what I will do, I will give you permission from the department. And for that, I will collect NOC also, municipality approval also, I only will collect in your behalf. But later on, if there are some changes in the guidelines, it's no more necessary, then I will not perform it, right? So I will say that it's no more necessary. So it's like I have already performed it, right? I don't need to perform that part. I don't need to take approval from that municipal body, or I don't need to take NOC from the community. Why? Because it's no more necessary. And secondly, it may be something which is excused under the law. Take for example, someone is excused, right? Under law, he is no more responsible. There is one contract between A and B. In the contract, they have clearly mentioned that in case any of us die, our legal representatives will not be under an obligation to perform this particular contract. It's only you and me who are under a legal obligation to perform it. So what will happen in that case? If either of the parties die, their legal representatives will be excused under law. They are not bound to perform that particular part, right? So under Indian Contract Act, we can say that the parties are excused from performing this particular contract. Why? Because there is a provision under Indian Contract Act section 37 that if contract specifically mentions that legal representatives will not be bound, then they would not be bound to continue with any kind of pending contract or contractual obligation. So these are the two things, okay? So in general, a contract should be performed. Whatever promise we make, whatever agreements we make with another person, it should be performed by us. Only exception that we have is when it's dispensed of, when it's no more necessary, or when it is excused under some kind of a law. Under Indian Contract Act or under different laws, it is excused. We don't need to perform that particular part. Law is giving us an excuse. So in that case also, we don't need to perform it. So in general, you can remember that whatever promise we make, it should be performed and it should be completed. Only exceptions are that it's no more necessary, or law is giving us an excuse that we don't need to perform it. So under these two cases, we don't need to perform it. Otherwise, we should complete whatever promise we have made under any kind of contract. So this is the first thing regarding performance of contract, okay? That contract which must be performed. So basically any contract or any promise should be performed unless and until it is dispensed with or it is excused under some kind of a law. It may be Indian Contract Act or it may be some other laws as well. So is this part clear, difference between what is dispensed with and what is excused under some kind of a law? Is this part clear? Neha, Vijay, is it clear?
Yes, ma'am.
Okay. Surya, is it clear?
Yes, ma'am.
Okay.
Yes, ma'am.
So basically what happens, whenever we make a promise, we should perform it. Only exception is that it's no more necessary to perform or it is excused under some kind of a law. So in that case, we will not perform it. Otherwise, we should perform it. Next is types of performance. Now we know that it should be performed, right? But how will we perform that particular obligation, right? Take for example, I made a promise and that promise I should perform. Now how I will perform it? There are two different ways of performing. First is actual performance and second is attempted performance or tender. So first is actual performance. What is actual performance? Any idea what is actual performance and attempted performance difference? It's very clear from the name itself. Anyone?
Ma'am, actual performance means what person has to be perform his duties. Actually, it has to be taken, like we will say, no, in general, like it has to be done like that.
Yeah, whatever I promised, accordingly only I perform. So actual performance. So what is actual performance? Whatever I have promised, I have done it accordingly. Take for example, I made a promise that I will buy your mobile phone for 5,000 rupees. So what I have done is that I gave you 5,000 rupees, and in exchange of that, I took your mobile phone. In that case, what happens? It is actual performance. Whatever I promised, accordingly only I have completed my promise, right? I gave you 5,000 rupees and I bought your mobile phone. So that will be actual performance. Whatever I promised, I did it accordingly. What is attempted performance? Attempted performance as in I made an attempt to perform it. Okay, take for example, there is one person, okay, who is, so this is very clear from the name itself. Okay, what is actual performance? What is actual performance? A made a promise to buy a mobile phone, for 5,000 rupees from B. A bought the mobile phone also, and also he paid 5,000 rupees. So in this case, what happens? Whatever promise was made, accordingly it was fulfilled. What is attempted performance? What is attempted performance? Take for example, there is one person A who is a painter. Take for example, who is a, okay fine, who is a painter. B hired him, okay? B hired him. So A is a painter. B hired this painter and said that I want to paint one of the rooms in my house, okay? I want to paint only one room in my house. So B hired A to paint one room, and he said that, okay fine, on like this coming Sunday you come. Or Sunday. Okay, so he specified also that this Sunday you come to my house and you paint this particular room. Now what happens on that particular Sunday? A went to B's house to get the painting done. Okay, so A went there. That means what? He attempted to perform his task, right? He was hired to paint the house, so he went there on that specific day only, and he made an attempt to perform it, right? He went there. But in that case, maybe B did not give him the paints, or he did not give him the brushes, or did not tell him which room is to be painted. So in that case, A do not have any other ways of performing it, right? So A made an attempt to perform it, but he could not perform it. Why? Because the other person, maybe he did not provide whatever was needed, he did not give proper instructions or something like that. So in that case, what happens? That is an attempted performance. That means the other person made an attempt to perform it, but he could not perform it. Why he could not perform? Because of this other person's fault only. Maybe he did not provide the paint, he did not provide the brushes, he did not say which room is to be painted. So in that case also, we would say that this person has made an attempt to perform. So again, later on, B cannot file a case against A saying that he, like he violated the contractual obligations. So why? Because A made an attempt to perform, but he could not perform because of the other person's fault only. Now take for example, A is a painter and he will charge, like, take for example 600 rupees per day for painting. He charges 600 rupees per day for painting. Now on that particular Sunday, he was waiting the whole day for B to come and give him the instructions and necessary things. So what happened? He wasted one full day because of B, right? So in that case, he can file a case against B saying that, like you did not allow me to perform my part of contract. I gave an offer also, you did not allow me to perform it. So you should compensate me for the loss that I have suffered. But B cannot file a case against A saying that you did not perform your contractual obligations. Why? Because this attempt was made, right? The other person went there, he waited the whole day for the instructions and for the necessary things, but he did not get it. So we can say that this person can file a case asking for compensation for whatever loss he has suffered because he was not allowed to perform it. He had to lose out on his daily wage of 600 rupees. So he can file a case accordingly. Now take for example A. A took 80,000 rupees from B. So what he said is that while taking the money, he said that I will return it within 1 month only. Okay, for a month. For a month, and the agreement was that I will return this 80,000 rupees to you within 1 month. And what would be the interest rate? It will be 10 rupees every single day. So 10 rupees will be added every single day till the time it's been delayed. Now take for example, after 1 month, A actually made an attempt to return the amount. A went to B and said that he want to return that amount of 80,000 rupees. But B said that I am busy. He said that I am busy, I cannot come and collect the money right now. So what will happen in this case? Will interest be calculated after this point also? Anyone? What will happen in this case? Like one person borrowed some money and interest was like daily 10 rupees will be added till the time you do not repay the amount. So A made an attempt to repay that 80,000 rupees, but B only said that I am busy, I cannot collect it right now. So what will happen in this case? Will interest be added after this point also or not?
Ma'am, after that prescribed period, the interest will stop because it is not his fault. The fault is on the other party. So he will be paying the prescribed interest only for that particular period, not beyond.
Yeah, not beyond. Yes. So he will not be bound to pay that rupees 10 interest every single day after that 1 month, right? Because on that particular time, he made an attempt to perform it. He made an attempt to repay or return that 80,000 rupees. So in such cases, this other party cannot take an advantage, right? Otherwise, he will obviously say, right, that today I'm busy, tomorrow I'm busy. Like that, if he keeps the other person waiting for a year, he will get a huge interest, right? So these kind of things should not be done. So it is said that once the person has made an attempt to perform it and he could not perform because of this other person's fault, any kind of interest will not be imposed on this person after that particular point of time. So after 1 month, if he comes to return the money, we do not accept it, he will not be liable to pay interest after that particular point of time. So same case would apply here also, that one painter is there, he was hired for a day and he was not given that particular task. So obviously he would lose, like he will suffer loss in terms of his daily wages. So that has to be compensated because you cannot just keep a person waiting for no reason. So why? Because this person made an attempt to perform it. So this attempt to perform, right, it is also like having same importance like performance only, because this fault was from the other person, right? I made an attempt to perform it. From my side, there was no fault. Fault was from the other person. So I should be compensated, or I would not be liable for any kind of consequences, right? Because I tried to perform my part, but obviously I could not perform it without the other person's help. So I had to stop at that point. So these are the two different types of performance that we have. Okay, so one is actual performance. Whatever was there, whatever things were there, accordingly only I performed. Another one is attempted performance. I made an attempt to perform it, but because of other person's fault, I could not perform it. But in this case, right, attempted performance, it has to be other person's fault. It should not be like it's my fault or something like that. Take for example, this promise was that this regarding the painting thing only we would take. Okay, so A was a painter and B hired him. So B wanted him to do some kind of a design, okay, some specific design in the walls. Now A later on says that no, I don't want to do this particular design because it would be time consuming. I will simply paint your walls or something like that. So that should not be done. That means when I'm making an attempt to perform, I should not put certain conditions from myself. I cannot say that no, I'm not doing it this way, I'm doing it this way only. I should not do that. Whatever I agreed at that starting point, accordingly only I should make an attempt to perform it. If I am making some kind of changes to it, obviously the other party would refuse, right? That time I would not get the benefits. But when I'm trying to perform my part without any conditions, without any changes, then also other one is not allowing me, then only I would get the advantage that I have made an attempt to perform my part, but I was not allowed to perform it. So these are the two different types of performance. So first thing that we have seen is that in general what happens, a contract is to be performed. So this was the first part, okay. Contracts must be performed, right? So first thing is that whatever promises are being made, those should be performed. Only two exceptions are there. One is it's no more needed. Another one is it's excused under some kind of a law or under the Indian Contract Act. In that cases, I'm not responsible to perform. Now, when I'm responsible to perform, how can I perform? It may be of two ways. It may be actual performance. Whatever was there in the initial offer and acceptance, accordingly only I have performed it. So it is actual performance of the promise. Or it may be attempted performance. I made an attempt to perform my part of obligations, but the other party did not allow me or did not give me the chance to perform it. So in that case also, I am not responsible, but the other party might be responsible to compensate me for any loss that I may have suffered or things like that. Take for example, if A is a singer, okay, and during some kind of festival or something, like when they have a lot of offers from different people or different organizers to sing at their place. So during that time, if a singer makes a commitment at some place for a certain amount, he goes there and then he was not allowed to sing. In that case also, he can ask for compensation, saying that I refused so many other offers because of this commitment, and now they did not allow me to perform it. So in that case also, he can say that I made an attempt to perform it, but what happened is that they did not allow me to perform this particular contract. So in that case also, it would be applicable. Same you would see in case of, take for example, photographer, right? Photographer or some other event management companies or something like that. What they will do is that they would take a certain amount advance, right? Take for example, they would take like 20-30% of the total amount as advance payment. Why? Because if at the last moment you are refusing or you are saying that event is cancelled or something like that, they would not return this advance amount. Why? Because they missed out on so many other opportunities, right? Based on your commitment, they refused many other clients. So they would take some amount as an advance, and even if you are refusing at the last moment, they would not return that advance amount to you. Why? Because they had to suffer some loss. They kept waiting for you and you did not allow them to perform it. So those things we see, right, in general, like for any event, for marriages and all, when you want to hire a photographer or something like that, right, makeup artist and things like that, they would charge a certain amount as advance. Why? This is because of this reason only. If you cancel it at the last moment, because from their end they wanted to perform it, you are refusing it at the last moment, so it's like a compensation for the loss that they have suffered. So they do it in advance only, but in certain cases maybe parties have not taken any advanced amount or something like that. In that matter, case can go to the court, and court might say that okay fine, this party has suffered a huge loss, you should compensate them for the loss that they have suffered because of you. Is this part clear? Performance of contract, what are the differences?
Yes, ma'am.
Others, is it clear? See, anything is not clear, you can tell, right? Otherwise we will just move with the remaining topics and something might not be clear. Is this part clear?
Yes, ma'am.
So first thing what we know now, that contracts should be performed in general unless and until it's no more necessary or it's excused under some law. How we can perform it? It may be actual performance. We have completed it based on whatever terms, conditions and everything was there, or we made an attempt from our end without our fault, the other party did not allow us to perform it. So that will be attempted performance. So this was the second part that we have. Now the second part that we have is by whom contract should be performed. So we know that contract should be performed, right? In what all cases it should be performed, how it should be performed and all of that. But now who are responsible to perform a contract? First of all, the promisor himself. So if take for example in the contract, right? In the contract itself, maybe I have specified that it should be performed by this specific person only. In that case, it should be performed by that person only, like the promisor himself. Now, any example that we can take for example, promisor himself. Okay, take for example, for this promisor himself, we would take an example, okay? Maybe I am a person who is providing content writing services. I am providing content writing services, okay? So there is one person B who is a prospective client. Now B reads a certain write-up that I have as a sample. So B reads that particular write-up and he comes to me saying that I want you to write an article on this particular topic. So in that case, what happens? B wants me only to write. Why? Because he wants that particular way of writing only. So in that case, who should perform it? It's me only who should perform it. That is the promisor himself. I cannot give that task to someone else. Why? Because he may not be looking for that, like everyone has different way of writing, right? So he may not be looking at that way of writing. So it should be performed by me only. Take for example, I am a painter or I'm an illustrator. What I do is that I make some drawings or cartoons for different books or like cover pages of different books. In that case, what happens is that B is a person who liked my paintings and he approached me whether I can make some drawings for him or not. In that case, I should not delegate that to someone else, right? I should not ask some other person to do the task. Why? Because in that particular contract, B wanted me only to make the paintings, or B wanted me only to write that particular article. So what I should not do, I should not give it to someone else. It's only me who should perform it. It's only me who should make the painting or who should write that particular article on his behalf. So it is the promisor himself, the first one, where it may be indicated by the other person that it should be done by you only or things like that, where it should be done by me only. I should not give it to someone else. Next is promisor or agent. So there may be certain situations where it's not been specified who should perform it. It may be either me or someone else also, right? My agent, my co-partners, or someone like that. So take for example, there may be one, take for example, I'm having like a Xerox shop. Okay, now in that case what happens, it's just I need to Xerox those documents, right? It do not involve any kind of skill, right? Like it involves in case of content writing or making a painting or something like that. What I need to do, I just need to take photocopies of that particular document. So if A comes to me and says that I want to get this particular like book, get a Xerox copy of this particular book or this particular document, maybe I would take that and I may ask someone else also, right, who is there at the shop to get the work done. Why? Because it do not involve any kind of special skill, or the other person is also not saying that it should be done by me only. Why? Because it is something that can be done by anyone who knows to operate that machine. So in that case, it may be the promisor or his agent. That means it can be done by me, or I can ask someone else also to get the work done. So in that case, it may be performed either by me or someone else also on my behalf. Next is legal representative. So when legal representatives will be liable, anyone? When legal representatives will be liable to perform the contract?
When the person probably passes away or without performing the contract, maybe his son or daughter, or whoever the legal representative, they can come forward and fulfill the terms of the contract.
Yeah. So in all cases, will they be liable, or in some cases they are not liable also?
I think there's the separate section for that. In what cases they are liable, if they are an interest to the part, the consideration of the contract, then they are liable, and yeah, in some cases they are not liable.
Yeah. So if they and also if in the contract itself, if like it is specifically mentioned that the parties or the legal representatives will not be liable in case the parties die before performing that particular contract. So in that case also, so this is section 37 of Indian Contract Act that says that if in the contract itself we are specifying, right, if there are like two persons involved, they made an agreement and they clearly mentioned in the agreement itself that it's only us who will be liable. In case we die before performing the contract, our representatives will not be liable. So in that case, they will not be liable. It may be expressly they would mention, or it may be implied from that particular like written contract that they did not wanted their legal representatives to perform it, or they did not wanted the obligations to pass on to their like next generation. So in that case, they will not be liable. Otherwise, the legal representatives may also be made liable. If the case goes to the court might say that, okay, fine, like the legal representatives or the next generation people are also liable to perform it. There is also one provision under Specific Relief Act also. So it basically says that there might be certain situations where it involves some kind of a skill, okay? Maybe I am a painter, okay, but maybe my next generation, no one knows how to paint something. So if I make a contract with someone to make some paintings, that contract cannot be performed by the next generation, right? So sometimes what happens, it may be involving some kind of a specific skill. So that skill might not be right? My legal representatives might not be having that skill. So those would not be liable. Or in some cases in contract itself, I have specified that it should not like go on to the next generation. So in that case also they will not be liable. Otherwise, legal representatives may be made liable in case the parties die before completing their promise, right? Before completing their promise or obligations under that particular contract. If they die, then they might be liable. Take for example, I am having like a shop. Take for example, this example only we can take, okay? I am having a Xerox shop, I took some kind of materials. Okay, maybe I took 5 books from a person B, and I said that I will get this, like photocopies done. In that case, if I die before completing this work, maybe he can ask the person who like who is there after my death, who is there at that particular shop, maybe my next generation people. So he might come and ask them to get the work done. Why? Because it is not involving any kind of like special skill or anything, and it can be performed anyways, right? But if it is like very complicated thing or anything like that, the facts of the case, the court might decide whether it should be performed by them or it should not be performed by the next generation. So the court would have that discretion to decide whether it should pass on to them or it should not. Next is by third persons. So third person as in someone who is like a stranger to the contract, okay? So third person as in what I can say is that, take for example, there is a like an offer and acceptance between 2 persons, okay? Take for example, one person, there is one person A who provides home delivery of, take for example, he provides home delivery of foods. Now what is the usual process? He only goes and gets the food delivered. Now one day he cooked the food and everything, but he was not well, he could not go to get the food delivered, so he asked someone else to get it delivered. In that case, what he is doing is that he asks a third person to perform his part of contract, right? So in that case, third parties may also perform it. So take for example, what I did is that I also took the delivery from that other person and I like enjoyed the food and everything. Later on, I cannot file a case against the person saying that it was performed by a third party. Same would be applicable. Take for example, if there is one person who is into stitching of clothes. Now what happened is that I wanted to get something stitched. I gave the material to them and everything, but it was stitched by someone else. Now I I took that, I owed it and everything, and later on I cannot file a case. Why? Because I accepted it at the first place, I used it and everything, so later on I cannot file a case saying that it was done by a third party. So it can be done by a third party also when I'm not specifying that it should be performed by this person only. It can be done by third persons also. And if I'm accepting that person's work and I'm like utilizing it, later on I should not be filing a case saying that this was done by someone else. Next is devolution of joint liabilities. Now sometimes in one contract, it may be not just one and one, 2 persons, right? It may be one person making a contract with several other persons, right? Maybe one person is making contract with 2, 3 persons. Take for example, A made a contract with B, C and D. Okay, B, C and D are like a group of people, okay, like partners or something like that. And A made a contract with B, C and D. In that case, what happens? B, C and D would be jointly liable, right? D would be liable to perform that particular contract. In case one of them dies, in case B dies, then what happens? B's legal representative and C and D would be liable. In case C also dies, B's legal representative, C's legal representative and D would be liable. In case D also died, all these legal representatives will be liable. So this is devolution of joint liability, when there are like a group of people and it's like a joint liability. Everyone is liable to perform their part of contract. In that case, all of them would be liable. One of them dies, their legal representatives would come into picture. So all these remaining people and the legal representative would be liable. Once all these people die, only the legal representatives would be liable. So this is devolution of joint liability when like the obligation is on a lot of people, right? Not one, more than one people. Then what will happen? It's like a joint liability. All of them could be having that responsibility of performing it. So by whom contract should be performed? It may be performed by the promisor himself if it is specifically mentioned in the contract. He should not delegate that work to someone else if it is specifically mentioned in the contract. You can take the example of anything that involves a personal skill, right? Singing, painting, writing, or anything which involves a certain skill, right? That needs a skill. Next, it may be done by the promisor or agent where it is not specified who should be doing it. Maybe I am providing content writing services, but what happens, along with me, there are 5 other people who are working. In that case, if you are not specifying that it should be written by me only, I may ask those other people also to write. Why? Because we are working as, like as a partnership. We 5 are working, so maybe our writing writing style and everything also might be same. If you are not specifying who should write it, it may be written by any of us. It may be written by me, by someone else also. So the promisor or the agent. It may be done by legal representatives when I die and I have not clearly specified that my responsibility should not pass on to my legal representatives or next generation. It may be done by some third parties also when I have not specified that it should be done by you only or your representatives or this specific person only. So it can be done by any third party. Take for example, like one person is providing some kind of a service. Maybe he is providing contract drafting services. Now, what happens is that he is caught up with some other work. He cannot get the work done. He may hire any other law graduate to draft the contract, right? It's not a big deal. He would give a template and say that you draft it based on this template only. After you are done, I will review it. So it can be done by some third persons also. Some third party is doing that drafting thing. And last one is devolution of joint liability. When there are more than one person, all of them would be responsible, and after them, their legal representatives would be liable. So they will have a joint liability to perform that particular thing. Is this part clear? By whom contracts should be performed?
And what if legal representative dies?
What if legal representative dies? Say after, after someone will come, right? Take for example, A made a contract with someone. A is having like 2 sons. Maybe the first one would be his eldest son. If he also dies, maybe the next son. If he also dies, maybe someone would get that, right? Maybe his relatives, maybe some like some employees of that particular company or something like that. Whoever gets that particular thing, right? If it's a company, whoever, maybe someone might buy the company, someone might start managing the company. So whoever comes in that position next, that person only would be liable. Like someone would be there, right? So that person would be liable. In case it's like a situation where the father died, maybe 2 of his sons died. Now there is no one to continue with that particular business. It should be shut down or something. Obviously, in that case, it would come like impossibility of performance, right? No one is there to perform it. Company is shut down or something like that. Obviously, then in that case, we cannot perform it. But otherwise, till the time at least someone is there to perform it, that person would, like perform that particular obligation.
Also, it can also be determined as to how much share that particular legal representative is holding in the property of the deceased. On that basis, also we can determine till how many generations that particular legal representative will be liable.
if it is a partnership, then the question would come regarding how much percentage of share the person was holding. In that case it would come like he's having multiple sons and then sons died, their sons, like grandsons, something like that. In that case it would come like who is holding how much percentage of share and things like that. If things go so complicated, then obviously court would come into picture and court would decide what should be done. Like the case would be filed for maybe like specific performance of contract, right? Under specific relief act that we see, lot many cases are filed for specific performance of contract. So in such cases, courts see the situation, what can be done, what would be best to do at that particular situation, so court can decide accordingly. So for such matters, this is the reason why court has been given the discretion, because we do not know what kind of situations might come in front of us tomorrow. So it's better not to have like one single rule, like 1 + 1 = 2. We don't have that kind of a rule. Court would see the situation, then court would decide that okay, fine, in this case you do it, in this case maybe it's not advisable to perform it or something like that. So court has been given the discretion, but in general it's legal representative, it would pass on, or whoever is holding it next. So is this part clear, who should perform it? Any doubts on this part, second portion? So this is regarding sections 40 to 45 that says who should perform it. Once we make a promise, who can perform or complete or fulfill those obligations. Now next is time and place of performance. Time and place of performance, there are it's sections 46 to 50. Time and place of performance, sections 46 to 50. Now there may be a contract between two persons where what happens is that time for performance is not being specified. So in that case what happens, it should be performed within a reasonable time. Take for example, maybe I would say in what case I can say like a time frame is not been specified. Maybe I'm saying that I want to take for example, there is one company who wants to buy some kind of office furnitures. So they have published one tender and they asked one person to supply those office furnitures to them. So in that case, what they can say is that they may not specify a time frame that within 5 days only you should be supplying those office furniture to me. Why? Because they are already having some like chairs and tables to run the office, but they want to replace them with new furniture. So in that case, might not be, they would say that okay, fine, within 5 days only you should supply. So a time frame has not been specified within what it should be done. Then what happens, it should be done within a reasonable time. That means maybe within 15 days, within 14 days maximum you should supply them, right? What is reasonable time, within that only you should perform it. Now again, what is reasonable time? We do not have like one single rule for that, right? It would depend on the situation, facts of the case, what is reasonable for what kind of a situation. Maybe if I'm saying that I want some office furniture to be supplied to me, in that case maybe reasonable time might be like 1 month, 15 days, 14 days or something like that, because till that time I can wait. Maybe there is one hospital and that needs some kind of medicines or supply of oxygen or something like that. In that case, what is reasonable? Maybe 24 hours would be reasonable, maybe 6 hours would be reasonable. So what is reasonable, we cannot say that okay fine, this is only what is reasonable. It would depend on the situation. So when I'm not specifying a time frame or something like that, it should be performed within a reasonable time only, based on the situation, based on the type of contract that we are having.
How does court shall decide the reasonability of the performance of a contract.
Yeah, so
At
court would,
reasonable time, how would they come up to a conclusion that he did perform within a reasonable time or he did not perform within a
yeah.
time?
Yeah. So basically, courts would see the situation, right? Whether it was supply of office furniture, whether it was supply of oxygen to a hospital, whether it was supply of blood to a hospital. So there is a difference, right? Courts would also know that for office furniture, what was the situation? Were you having some old furniture to run the office? If yes, maybe you can wait for 1 month, no problem in that. If it is supply of some blood or oxygen in a hospital, you cannot wait for more than a day, right? So accordingly, court would decide based on the situation what type of contract you were having and also what were the existing situation. If it was for supply of office furniture, whether you were having some old furniture to run the office, continue your work or not. So there would be multiple factors that court would look into. Also, sometimes you would see court would hire some experts, right? So what court would do is that court would hire some experts who know regarding that particular field. Maybe the magistrate might not be having that much knowledge about how important it is to like if a hospital wants supply of blood, how urgent is it? Might be a magistrate might not know. So in that case, they might hire some medical practitioners, some other people who are expert in that field, and they would say that what would be the gravity of the situation. In case a hospital is in need of some oxygen or blood, what is the urgency of that matter? Do you need it within 2-3 hours? Do you need it within 1 day? 5 days, 6 days? What is the time frame for which you can wait? So accordingly, court would decide what is the reasonable time. In case court can see the situation and themselves feel, they would decide accordingly. If it's difficult for the court to decide what is reasonable, what is, like if a lot of technicalities are involved, they might even hire some experts on that particular field to know what was the situation, what is the gravity or urgency of that matter. Accordingly, they might decide that, okay, fine, this was a, like time frame till which the people, like they could have waited or something like that. In case of office furniture also, 1 month may be a reasonable time, but 6 months would not be a reasonable time, even if you are having some old furniture. Why? Because in those old chairs and old tables, it was difficult for the employees to work. Their productivity was reducing. They cannot work and sit there for 9 hours, 10 hours and work. So in that case, again, court might say that, okay, fine, 6 months is not reasonable just because they were having some old furniture. So it would depend on a lot of factors also. Like apart from the situation, a lot of other factors that were there. So accordingly, they should be deciding. So next is when like time is specified. Okay, so performance of promise where time is specified. It might happen that I have specified one time frame. Okay, I have specified 1 day, but I have not specified that, okay, fine, like from 11 to 12 o'clock only it should be done. I have not specified a time frame, but like a specific time I have not specified, but I have just given you a rough idea about the date. Then what happens? It should be done during usual hours of business in that day. Maybe take for example, I hired some kind of a person who are into like event management. Okay, they decorate all these, like marriage hall and other places. So I hired someone and I said that on like 10th of October, there is some event. So you need to decorate this particular hall. In that case, what they should do, and I told them that this, like hall is free from 7th to 10th. It is free. On 10th, we have the event. So they can decorate it within a reasonable time. If they are using fresh flowers, maybe 1 day before they can decorate or something like that. But it should not be like on 9th at, like 3 o'clock at night they are going. It should not be like that. Why? Because it might be closed. So it should be within reasonable hours, like during that particular time frame what I have mentioned. It should be done before 10th. From 7th to 10th, it should be done during reasonable hours when it would be feasible for them. They cannot do it on 7th and on the day of marriage, all the flowers are, like all the flowers are, you know, like they are no more fresh or something like that. It should not be like that. So when like a time is specified, but I have not said that during, you know, like from 11 to 12 o'clock only you should come and decorate the hall, then they would decide what would be the time frame, when they would come, how much time they would need, and accordingly they can decorate it. So for this, you can remember this decorating a marriage hall example, that it should be done before marriage, and they can decide when they would do it, when it would be perfectly done, and all of that. So first is when time is not specified, it should be done in reasonable time. If I'm specifying a time frame, but not, you know, like a date I am specifying, but not that specific time, then in that case, they should do it within a reasonable time only. Whenever it's possible for them, they should do it within like usual hours of that particular date, they can do it. So next is performance of promise. Performance of promise on an application by the promisee. So sometimes what may happen is that there is one agreement between two persons. Take for example, there is an agreement between me and you, but I cannot perform it unless and until you ask me to perform it. Take for example, you are hosting some kind of an event, and I am there to sing a song or some kind of performance. In that case, until and unless you call me to the stage, I cannot perform it, right? So in that case, what happens? Performance of promise on an application by the promisee. You should ask me, or you should give me that chance to perform it. So take for example, I am a singer and you are the host of a certain event. When I will perform it, only when you demand it, only when you call me to stage, I can perform it. So in that case, what happens? It should be done when, you know, like when you are demanding it, at that point of time only the other person can perform it or can fulfill his part of contract. So in that case also, what I will have to do, take for example, you mentioned that on 7th we are organizing this particular event and you can come there and sing. What happens is that I should be present at that particular place on 7th, so that I'm available whenever you call me, I can perform. So it is what should be done, that when it depends on your demand, whenever you ask me to perform, then only I can perform. I should be available during that particular, you know, like time frame at that particular space, at that particular place, so that I can perform whenever it is demanded. So this would be even applicable for like job interviews. If you are going for an interview, if they call you that, okay, fine, on 7th you have an interview, so you can come there at 10 o'clock. You know, like you cannot just go there at 10 o'clock and you cannot just directly enter to the manager's cabin, right? They should call you that, okay, fine, now it's your turn, you come and attend the interview. Then only you should do, you know, like do. So that is also something that you would do on application. The other person will ask you, would demand from you that now you come, it's your turn to attend the interview. Then only you can perform it. But for that, you should be present on that particular, you know, like at that particular venue on 7th for the interview, so that the other person can call you for the interview and take your interview accordingly. So first is no time specified within a reasonable time. Second is time frame is specified but time is not specified. Then within a reasonable time, during usual hours we should do. It may be something that depends on the other person's demand or application. In that case, we should be available at the venue during the time. Whenever it is demanded, we should perform it, like going for a job interview, going for some kind of performance or something like that. Next is performance of promise, where no place is specified and also no application is to be made by the promisee. So sometimes what happens is that it, you know, like no place is specified. You have not specified the place also, and it's not like on your demand it should be done. So in that case, what I will have to do is that I will have to ask you what should be done. Take for example, you said that like I am dealing with some kind of oil. You said that I want 100 liters of coconut oil for my business. Now in that case, you have not specified where your like factory is located, where you reside or anything like that. So in that case, I don't have any idea where I should get that oil delivered to you. So what I should do is that I should ask you, where can I deliver those 100 liters of oil to you? What is your office address? What is the address of your factory or residence where I should deliver it to you? So accordingly, I should perform. So if you are not specifying any place also, and you know, like it's not like you would come and demand then I would supply, then I will have to ask. If it's like you will come and collect that oil from me, then I can just, you know, like wait for you to come. But if it's not like that, I only should go and deliver, then I should be asking you where I should get it delivered. Next is performance of promise in the manner and time sanctioned by the promisee. So in case I have specified a manner, time in that particular offer only, while giving the offer only, I said that you should be supplying 100 liters of coconut oil to me on 7th of October at my factory address, and this is the address. And you should be supplying it to me during, you know, like during the evening, maybe like 4 to 8 o'clock. In that case, you should be doing it accordingly only. You should deliver it to my factory address only. Anytime between 4 to 8 only you should come and deliver. So if time and manner is specified, you should do it accordingly. If nothing is specified, you should ask for it. If it is like on demand, it should be done, then you should be available at the place so that you can perform it whenever it is being demanded. In case like time frame is mentioned but time is not mentioned, it should be during reasonable or usual hours of that particular time frame. If nothing is being mentioned, time is not mentioned, that it should be within a reasonable time that it should be performed. So is this part clear? Place and time for performance of contract.
Yes, ma'am.
So it's like very simple, right? Normally also what happens, right? Same thing. If we are ordering something online, first thing that they would ask for is, they would ask for our address, right? Where it should be delivered. Accordingly, only they will deliver to that particular address. For some shopping sites, you would also get to select like time slots, right? That it should be delivered. Like take for example, you are ordering grocery or something, then you would get time frames that it should be delivered from 4 to 8 o'clock, 9 to 11 o'clock or something like that. So accordingly only it should be delivered. So same thing applies here also. In case of this particular type of contract, if I'm specifying a time frame or something like that, it should be done during that time frame only, right? If I'm ordering something online and I have selected a time frame that, okay, fine, on 7th you should deliver during, you know, like 8 to like 4 to 8 o'clock, you can deliver anytime. So they cannot come at 2 o'clock and say that, okay, fine, you take delivery of the goods. Why? Because I may not be available, because that is not the time frame that I mentioned. So it should be done accordingly only, whatever is being mentioned in that particular contract. If I'm not mentioning, it should be during a reasonable time frame. Take for example, you are ordering something from Amazon, you're ordering something from Flipkart. They just tell you that, okay, fine, it will be delivered maybe like between 10 to 12. They do not say, right, that it will be delivered at this particular time, right? Time they do not specify, they just specify the date. But when they are not telling you any time, they would deliver it at a reasonable time frame. Morning 5 o'clock they won't come, they might come morning 8 o'clock. Night 12 o'clock they won't come, might be night 10 o'clock they might come, right? So what is usual time frame, during that only they would come. So this applies even in our like day-to-day life also. So what happens, same thing applies here also, right? Accordingly you can relate to that okay, fine, when we are ordering something online, what we do, Same thing only applies here also. Time and place for performance. Because that also is a type of contract only, right? I'm buying something online, I'm paying for it, and they are delivering it to me. That is also a type of contract. So whatever applies there, same thing you can apply here also. Time is not specified, it should be reasonable. Time, date, everything is specified, it should be done accordingly only. Next is performance of reciprocal promises, sections 51 to 58. Now in the contract itself, there might be something, right? That you do this, I will do that. That kind of promises might be there. So take for example, when we are ordering something and we select cash on delivery option. That is what, that is kind of a reciprocal promise only. You deliver the goods to me and I will pay you, right? It is like you give, like give and take, right? You give this to me and you take money for that. So this is also regarding that only, performance of reciprocal promises. The first thing you can relate with ordering something on cash on delivery thing. Promisor not bound to perform unless reciprocal promisee ready and willing to perform. What is it? Take for example, you ordered a book or you ordered a mobile phone online and you selected cash on delivery option. What happens is that that person came to you and said that, okay, fine, this mobile phone is for like 15,000 rupees, and you like pay it cash or card or whatever mode you want, you should pay it. Unless if you say that, oh, now I don't have money or something like that, will they deliver that phone to you? They will not deliver, right? Why? Because it's a reciprocal promise. You do something, the other person will do something. If you are not giving that 50,000 rupees at that moment, the person will not deliver the phone to you. Why? Because it's a reciprocal promise. You do something and you take something in return of that. So unless and until you are ready and willing to pay 15,000 rupees, the other person will not deliver his phone or that particular parcel to you. So this is what section 51 is all about. You can just remember simple way that just, like ordering something on cash on delivery, until and unless you are ready and willing to pay for it, they will not deliver that goods to you. Next is order of performance of reciprocal promises. So order of performance of reciprocal promises. What are reciprocal promises? Like there are multiple things involved, right? You do this, then I will do this. I will do this, then you do this, or things like that. So order of performance of reciprocal promises. If order is fixed, if I'm saying that you do this, then I will do this, then you do this, then I will do this. If order is fixed, it should be done accordingly. But sometimes it may be that order is not fixed. Then it should be done in a, like what is, how it should be performed, right? Accordingly only it should be done. Take for example, like you hired a person to paint your house. Or maybe you hired some interior designer to, like renovate your house. In that case, what will be the usual flow of things? First of all, you should tell them about what all changes you want to make at your house, what is your budget and all of that. Secondly, maybe you will have to vacate your house. Thirdly, they will come, they will do the things, they will renovate and everything. Fourthly, you will have to pay. Fifthly, they will hand over possession to you, right? So what happens is that it is a sequence of events, right? You do this, they will do this, then you do this, then they will do that. Take for example, you want to get your house painted. You hired a painter. What you will have to do, first of all, you will have to tell him that, okay, fine, in this particular wall, I want this particular paint. This room, I want this type of paint and all of that. Secondly, you will have to supply those paints, brushes and all the other equipments. Thirdly, they will paint. Fourthly, you will, like come supervise, see anything needs modification, you will ask for it. The person will do, and finally you will make the payment. right? So what is reasonable, accordingly only it should be done. The person cannot straight away come and say that, okay, fine, you pay me the entire amount, then only I will pay. Or you cannot say that, okay, fine, you know, like get the work done, I don't, you know, like you are not supplying the paints, or you are not giving the directions, you are not telling what paint should be done in which wall or anything like that. So you cannot expect the person to do, right? So it should be done in that usual order only, how it should be done, right? How it should be done in order to complete this entire task. Unless and until you are supplying the necessary items and giving the necessary directions, you cannot expect the person to complete his task, right? So whatever is usual and reasonable, it should be done accordingly. Is this part clear, these two sections?
And when the order is not expressly fixed, that means like it should be performed in a reasonable manner, right? Like,
yeah, reasonable manner.
Oh.
If I am hiring a painter, obviously what is reasonable is that first of all I should tell him that, okay, fine, I have 5 rooms, I want to get painted, only 2 rooms I want to, you know, like paint. What color I want, which wall I want, I should tell him, right? Then I only should buy the paints, brushes and all of that. Then only he will paint. Then I will see. Then I will tell him, okay, fine, everything is fine, then I will pay. So that is usual mode. But I cannot expect him to just come paint and do everything. I will have to tell him. So that is usual mode. If not mentioned, it should be usual. If mentioned, it should be according to that particular order only. Anyone having any doubts this part? Anyone having any doubts these sections, or we will proceed with the other ones? Is it clear, Mamta?
Yes, ma'am.
Any doubts?
No, ma'am. No.
So next is liability of party preventing event on which the contract is to take effect. So sometimes what may happen is that one person, right, like there are 2 parties in a contract, this one person, he only prevented the other one from performing his promise. Then what happens, it becomes voidable on the other person. One simple example we can take for example, you ordered something from Amazon, they came to deliver it to you, but you were not available. In that case, what happens, it would depend on them whether they would again come, they would make a second attempt or not. In general, it's like 3 attempts they would have, but take for example some other like DTDC service or some other courier service you have taken, you did not accept the parcel, maybe you said that I'm not available at the place or something like that. So now it depends on the service provider whether they want to make a second attempt, third attempt, fourth attempt to deliver that item or not. So what happens, it becomes voidable. Once there is a contract between 2 persons, me and you, I came forward to perform my part, but you prevented, you did not allow me to perform. Now what happens, it depends on me whether I would again like to go and approach you and ask you whether I can perform it or not. So what happens, it becomes voidable who has been prevented. If you prevent me from performing my contract, it becomes voidable at my option. Now I will decide whether I want to make a second attempt to perform it or not. So this is what section 53 is all about. So you can just try to relate this with, you know, like day-to-day life examples. So these type of situations we come across, right? In general also we come across. So accordingly only you can relate to this. Sometimes what happens, maybe some department or someone has sent you a letter or some important documents by post. Postman came to your place, you were not available. So postman might not come again to deliver that letter. They might say that now you go to your nearest post office and collect it from there. So what is it? It has become voidable, right? Postman has decided now that I will not make a second attempt to deliver it to you. Now you come to our post office and you collect that particular document from us within 7 days. Otherwise, we will return it to the other person. So what is that? It becomes voidable, right? So simple day-to-day life examples, you can relate these things, right? It happens with us also. It becomes voidable, right? Like post office and all, DON comes 2-3 times if you are not accepting something, so you will have to go or something like that. So accordingly only you can relate this provision. So next is effect of default as to that promise which should be first performed in contract consisting of reciprocal promises. Now here also you can take that same like painting example only. So what is reciprocal promises? There are more than one promises, okay? So rather than reading the provisions, you can try to relate it with normal examples that we see every single day. Take for example, there is a reciprocal promise. What is reciprocal promise? There are multiple promises. One thing cannot be performed unless and until this other thing is performed, right? So what will happen in that case? This is what section 54 is all about. Effect of default as to promise which should be first performed, as in if there is a contract between us regarding reciprocal promises, you should first perform your part, only then I will be able to perform. So if you do not perform it, what will happen? That is what it is all about. Take for example, if you are hiring a person to paint your house, what you will have to do, first of all, it's your responsibility to give him all the instructions that this is how painting should be done, this is what color you should use, this is how you should use it. Secondly, you should supply all the necessary things like paints, brushes, and all of that. So this is the first part that should be performed. Unless or until this first part is performed, I cannot paint the house, right? So in case you are not giving that necessary directions, necessary supplies, what will happen? I cannot perform my part of contract. I will be simply waiting for your directions, your advice. So what happens is that it's a loss for me, and you may be liable to pay compensation to me also. Why? Because I will be waiting the entire day, waiting for your supplies, waiting for your directions. If you do not provide it, you may have to compensate me for my loss that I have suffered, right? In terms of my daily wages, you may need to compensate me as well. Now, sometimes what happens is that time is very important, right? When this contract is to be performed, time is very important. So what will happen in this case? Sometimes time may be very important. So if you fail to perform it within that time frame, it becomes voidable at my option. Take for example, I hired a person to decorate a hall for some kind of an event, maybe for Durga Puja or maybe for Ganpati. I invited someone to decorate a place. That person failed to do it within the reasonable time. Before Ganpati, he could not decorate it. Now what happens? It becomes voidable. I may cancel out the entire thing, or I may say that, okay, fine, this Ganpati I will manage. Maybe you can decorate it for Durga Puja or Diwali or something like that, right? For the next upcoming event, you may decorate it for the same price on the same clauses, whatever we agree. So it becomes voidable. When time is very important, when it should be performed, and the other person fails to perform it within that time frame, it becomes voidable at my option. I will decide when it should, whether I would want to proceed with it or I don't want to proceed with it. But if time is not essential, then in that case, it would not be voidable. So if take for example, there is one contract where I hired a person to decorate my home for Ganpati. He was not available, he could not do it. I told him that, okay, fine, you decorate it for Diwali. when he does that, when he decorates for Diwali, later on I cannot file a case saying that he failed to do it during Diwali. Why? Because I accepted this other thing, right? That I said that, okay, fine, leave it. If you could not do it during Ganpati, you can do it for Diwali. So after it's done for Diwali, now I cannot ask for compensation. But at that moment, I could have asked saying that he promised, but he could not perform it. So I should be compensated because I suffered some loss with regard to that. Is this part clear, these sections? Any section you want to be repeated?
54 we repeated once.
54.
54, yeah.
54, okay. So 54 is effect of default. Effect of default. Default as in I could not do it. As to the promise, which should be first performed. So what is it? First, there are like reciprocal promises, right? There are multiple promises. This promise should be performed first, only then the remaining ones can be performed. But I failed to perform this, so the remaining ones could not be performed. So what will happen in that case? So take for example, there is a contract between you and me where there are 4 reciprocal promises. Until and unless you do the first one, the remaining ones cannot be performed. You fail to perform this first one. So what will happen? What will be the consequences? Like hiring a person to get the painting done. What is the first thing that should be done? You should give him the directions. You should give him the necessary things, but you fail to do that. So in that case, what happens is that it's because this particular thing was not done, the other person could not do it. So if this other person suffers any loss, you should be the one who should compensate it. If you hired a person to paint your house, he went there, he waited for you the entire day, you did not give him directions, you did not supply the necessary paints, brushes, you should compensate him for the loss that he suffered in terms of his daily wage, because he had to wait for the entire day. So basically, when there are multiple things, one thing should be done. Unless and until this is done, other things cannot be done. If you fail to perform it, you should compensate for any loss that the other person has suffered because of non-performance. Is it clear? Or you want some other example?
Yes, ma'am, I got it.
So basically 2-3 different promises are there. Unless and until this first one is done, remaining ones cannot be performed. So you will have to compensate the other person. Next is agreement to do impossible act. So there may be sometimes a situation might be there where what happens is that contract to do an act which afterwards become unlawful. So one agreement is made between 2 persons, but maybe later on some new laws came, new regulations came, and it became what? It became unlawful or illegal. You cannot do it. Maybe you said that I will supply some kind of a drug to you. Now what happens? Supply of that particular drug without permission or without prescription is not allowed. So in that case, what happens? It has become impossible or unlawful. You cannot supply it without a valid doctor's prescription. So in that case, what happens? Contract will become void because it has become impossible to perform it without having a valid prescription from a practicing doctor. So take for example, I made a promise to you. I know that it is something which cannot be performed or it is unlawful or something like that. Even though I made a promise, based on that, you were, relying on that promise. Later on, I said that, okay, fine, it's too unlawful, I cannot perform it. In that case, I will have to pay you compensation because you relied on my, my promise, and afterwards you had to suffer some kind of a loss. So in that case, I will have to compensate you for that. So it is basically with regard to agreement to do impossible act. If knowingly I am making such kind of an agreement and the other person is suffering loss, I will have to compensate for that.
I understand regarding the impossible performance, but if it's unlawful, like isn't both the parties bound to know even before they enter a contract?
Unlawful as in, see, it might be something which was, like take that drug example only. It was allowed that you can supply it to any and everyone. Now some new laws came, you cannot do it without permission, without a valid prescription or something like that. So now it has become unlawful. Initially might be it was not unlawful, or sometimes a person might not know. Take for example, okay, second one you are asking, right, that I should also be knowing that it's unlawful.
Yeah, because ignorance of law is, he cannot claim excuse regarding.
Okay, ignorance of law is not excusable, but take for example, you are dealing with some kind of drugs and you should be having, like permission from a certain government department. When you are, like you are the owner of a certain shop where you are selling drugs, I would assume that you have that particular, like permission or approval or license, whatever it is. But if you are not having it, then what happens? It becomes unlawful, right? You do not have permission to deal with it, but still you are doing it. So now it's unlawful, right? You do not have that permission. Still you made a promise to me that I will be supplying you these drugs. Maybe I need those drugs for some kind of a research or something like that. Based on your promise, I waited for you to supply those drugs to me and I kept my research on hold. Now I suffered a huge loss, so you will have to compensate me because you knew that you do not have permission, you do not have approval, still you made that particular agreement. Later on you failed to perform it because you were not having the permission. So in that case you should be doing it. So in that case I would not have any ways of knowing, right, that you have permission, you have approval, sanction.
Yes,
or
got
not.
it.
Yeah. So this is with regard to do impossible act. Then to do something, things legal and also other things illegal. So in one contract only there might be like 2-3 things, right? One is legal, one is illegal. So in that case, legal things I should be performing, and the illegal things, it would become, like void. Like one portion of that particular agreement would become void. Whatever is legal, that part I should perform. So it's like very simple only. In one agreement or one contract, there are two parts where one is legal, one is illegal. So legal part I should be performing. Illegal part, court may declare that, okay, fine, it's void, it's illegal. Alternative promise, one branch being illegal. So what is the difference between section 57 and 58 is that section 57 is, there are two things, right? Two separate things. One is legal, one is illegal. So legal thing I should be performing, illegal thing court would say it's void. 58 is alternate promise, that you either do this or you do this. So this one is legal, this one is illegal. In that case, the legal one would be valid. That means you should anyways perform what is legal. It does not matter that there was another promise which was illegal. So in that case, you will be bound to do it. Like take this example only, like some smuggled goods I want, or I want rice. So in that case, for rice, it would be valid. Whatever is legal, for that part, it will be valid. Next is appropriation of payment. Any doubts on this part? Performance of reciprocal promises. Any doubts, anyone? See, like, like knowing the entire provision or knowing the entire section is not that important. Basically, they would ask you questions from the section only. So you can try to remember the important sections. And also, like what is the basic thing about it? Like take, for example, legal and illegal, two things are there. Okay, fine. Legal would be valid, illegal will be void. So like that, you can remember. Knowing line by line the entire provision might not be important because they would ask you basically like objective type questions only, right? So try to remember the important sections for this. So this is regarding performance of reciprocal promises. Then we have appropriation of payment. What is appropriation? Anyone? So appropriation is like using, okay, appropriation of payment. That means you have received some kind of a payment where you want to use it. So for this, you can remember one example, that there is one person A who took 5,000 rupees and another 10,000 rupees from B. This was like 10 years ago. 10 years ago. And this was like 2 months ago. 2 months ago. So in that case, if B is receiving a payment from A, where he will appropriate that. So there are three situations where debt to be discharged is indicated. Now this first one, right, 5,000 rupees is taken 10 years ago. Is it like, can I file a case for recovery of that money after 10 years? What is the limitation period for recovery of money? Anyone? During what time can I file? Anyone remembers? So take for example, within 3 years, I should be filing a case for recovery of money. Now already 10 years has gone and the person has not repaid the amount. That means it's barred by limitation, right? Under law, he is no more liable to pay me. Now what happens? Where debt to be discharged is indicated. A has made a payment of 5,000 rupees to me and he said that this should be appropriated to this 10,000 rupees only. I took 10,000 rupees from you 2 months ago. So this is like one installment of that 10,000 rupees. So in that case, I should consider that this 5,000 rupees he is paying as one installment of this 10,000 rupees loan that he took 2 months ago. I cannot appropriate it to that 5,000 rupees loan, which is barred by limitation. Why? Because the person has clearly mentioned to what he is, like making the payment, regarding what he is making the payment. So accordingly only I should apply it. But in case debt to be discharged is not indicated, he just to give me 5,000 rupees, he did not tell me for what he has paid. So in that case, I have the option, I can tell him that you did not mention for what I should, like for what you are paying that 5,000. So now I'm considering you are paying that 5,000 rupees loan that you took like 10 years back, which is barred by limitation. I can appropriate it in terms of that also. And where even I am not saying anything, I just took the 5,000 rupees, he also just gave the 5,000 rupees, then what happens is that it would be applied in terms of, like order only. It would be said that, okay, whatever is the oldest loan pending, to that only it should be applied. So it will be considered that he cleared that first loan that he took 10 years ago. It does not matter whether it's barred by limitation or not. It would be applied in terms of, like time frame only. Whatever is the oldest one, to that only it will be applied. So regarding appropriation of payment, there are three things, okay? First is, I am telling it is with regard to this specific loan only. Then you can apply it to that specific loan only. If I am not specifying anything, it's your discretion. You can apply it to whatever loans are pending. If neither of us are doing anything, then it will be automatically applied to whatever is the oldest loan that is pending. So these are the like three simple provisions regarding appropriation of payment, okay? Where I'm telling you which loan it is, where I'm not telling you, it's your discretion. Where none of us are doing anything, it would be automatically applied to whatever is the oldest loan that is pending between us. Next is contracts which need not be performed. So sometimes, otherwise, we know, right, that contract should be performed unless and until it's like, like excused. It's excused under some kind of a law, or it's no more needed. But sometimes what happens, because like we may make certain changes to that particular contract, or what we may do is that we may make a new contract altogether or something like that. So in that case, what happens is that the previous previous contract that is there, right? That particular contract should not be performed. That particular contract should not be performed. So if it is what? It is novation. Novation as in making a new contract. There was already one contract existing between us, but we made a new contract. So that previous contract need not be performed. It may be recession. It may be we also, like we only said that this particular contract we are cancelling out. If we are only cancelling out, it need not be performed. It may be alteration. Contract was there, we made certain changes. So previous clauses need not be performed. Based on the new clauses only we should perform. So this is what should not be performed. If there are any changes or anything, then the, like previous things should not be performed. If promisee may dispense with or remit the performance. If there is a contract between you and me, I am only saying that, okay, fine, you need not perform it. It's not needed. It's not necessary. Then also you should not perform. Whatever I said, right? You should not perform this part. This part is not needed. It's fine if even if you do not perform it, then also you should not perform those parts. Regarding whatever I said that it should not be done or it's no more needed or something like that. Now, there might be a contract which is voidable, okay? That it depends on me whether I want to proceed with it or not. If that happens, what happens is that I will have to repay you any kind of benefits that I have taken. We discussed also, right? Mohri Bibi case, same applies here, 64 and 65. That, like mother said that, okay, fine, this Mohri Bibi said, right, that the minor should repay that amount that he has taken under section 64 and 65, but they said that 64 and 65 is applicable for void and voidable contracts, not for contract with minor. So in case a contract is voidable, parties do not want to proceed with it, any benefits that they have taken, it should be returned back. They cannot taking benefit, they should not be taking benefit or advantage from any voidable or void contract. In case a contract becomes void, then also whatever benefits parties have taken, that should be returned to the parties. They cannot be taking any benefits out of it. And when they want to, revoke or rescind any particular voidable contract, it should be communicated to the other party also. It should be maybe communicated by writing a letter or by doing certain acts or actions by which the other party understands that it is being revoked. Effect of neglect of promisee to afford promiser reasonable facility to perform. So in case I, I went to you, I wanted to perform my contract, but you did not allow, then what happens? I'm not responsible for non-performance. If I wanted to perform a certain contract, I approached you also, you did not give me an opportunity. Later on, you cannot file a case against me saying that I did not perform my part of contract. Why? Because I made an attempt to perform. So whatever section we did, right, before also, that I made an attempt, that only would be applicable. So whenever there is a contract, what is contract? It's a promise between two or more persons. Whatever promises are there, those promises should be fulfilled. Then we can say that this contract has been discharged. How it can be done? It can be by performing, it may be by mutual agreement, like making a new contract, cancelling out a previous contract, making some changes in the existing contract and things like that. It may be by operation of law, maybe to, because of merger, because of insolvency and all of that. It may be because of impossibility of performance, parties died, their legal representatives are not liable or things like that. So regarding performance of contract, what contract should be performed? Any promise, any contract should be performed unless and until it is dispensed with or excused under some kind of a law. If it is no more needed by the parties, or if it is excused under law, then only it need not be performed, otherwise it should be performed. How it can be performed? It can be actual performance. Whatever was the promise, I did it accordingly. It may be attempted performance. I made an attempt, but the other party did not allow me to perform my part of contract. contract may be performed by me if it specifically mentions that it should be performed by me, or if it involves some kind of special skills like painting, writing, and singing and all of that. It may be done by me or some of my agents if they have not specified anything. If some specific skills are not needed, then it can be done. It may be done by legal representatives in case I die and I have not specifically mentioned that obligations should not pass on to my legal representatives. Next, it may be done by some third parties also if it do not involve any special skills and if the other party also accepts it. Devolution of joint liabilities, if there are two or more parties on the other side, all of them would be liable. Any one of them dies, their legal representatives would be liable. All of them dies, their legal representatives would be liable. Is this part clear? See, any section or anything is not clear, you can tell, we can like repeat that particular part. Next is time and place for performance. So when nothing is specified, it should be within a reasonable time. If something is specified, it should be according to that only. Time is specified, place is specified, whatever it is, accordingly only it should be done. If something should be done on demand, it should be done on demand, and I should be available at that particular place. Like take for example, like singing at a certain event, I should be available at the place so that host can ask me to sing or perform. If place is not specified, then it should be during usual hours of that particular time frame. If manner and time is specified, it should be done accordingly only. Regarding reciprocal promises, there are multiple promises. Unless and until one thing is done, the other one will not do. Unless and until you pay, that cash on delivery parcel would not be delivered to you. So unless and until you are ready and willing to pay, the other person will not deliver that parcel to you. So it should be done in the proper order, how it should be done. If order is fixed, it should be done accordingly. If order is not fixed, it should be done in a reasonable way so that everything can be done properly. In case one thing should be done, then only the remaining ones can be done. You fail to do it, you are responsible for it. You may even need to compensate the other person for any loss that he has suffered. If any time frame is fixed, it should be done within that time frame only. Otherwise, you may have to give compensation to the other person also. If it is to do some kind of an impossible act or unlawful act, then also you are not bound to perform it. If it is something that involves both legal and illegal things, for legal things you are responsible, for illegal things you are not responsible. If there are alternate promises, one is legal, one is illegal, for the legal one you are responsible. Then with regard to appropriation of payment, there are three things. One, I am telling you this payment is with regard to this particular debt only. You should apply it to that debt only. If I am not specifying, it's your discretion. Wherever you want, you can apply. If no one has specified anything, it should be applied based on time frame only. The oldest one only, it should be applied. So what contract should not be performed? If there are any changes made to the contract, the previous thing should not be performed. If I am only saying this need not be performed, then you are not responsible to perform it. In case a contract is voidable or void, we should not be taking advantage or any benefits out of it if we do not want to proceed with it. We should be repaying that particular benefit or money that we have taken. If we want to revoke it, we should properly communicate it to the other person. If it should be, done by the other person, we should allow the other person also to perform his part. That the other person wants to perform his part of contract, we should allow the person to perform his part of contract. So any section or anything, any doubts you want to be repeated? Anyone? Is this part clear? Any section to be repeated?
Yes, it's clear, ma'am.
Okay. Neha and Vijay, is this part clear?
Yes, ma'am. Clear.
Okay. Fine. And so see, there are like few questions also, right? MCQ questions also. So that also we will see in next class, and also few more portion is remaining for general provisions relating to contract. So next class we will try to see some MCQs also, what kind of questions come, so that you get an idea how you can prepare for your exams. And also the remaining parts we can continue. So if any section or any part is not clear, you can tell me that this part should be repeated or something like that. We can repeat it at any point. Okay.
Can you share this PDF, ma'am?
Yeah, fine. Today I will share this.
Okay, ma'am. Thank you.
Yeah. Okay, fine then. So I'm ending this class. Okay, next Saturday we will see some questions relating to this previous part, and also the remaining portion we will continue. Okay.
Ma'am, do you cover any case laws which are required in the view of exam?
Yeah, like previous classes we discussed few of the case laws. For performance there are not like much landmark cases. Yeah, so that part I have already shared. You can see like in the group also I have shared the documents also.
Okay, ma'am. So all the landmark cases and
landmark cases and all are also there. Notes is also there. So from there you can like
yes,
see
ma'am.
and
I shall look into it definitely, ma'am.
Yeah. Okay, then fine. So we'll continue on this Saturday. Okay. Thank you.
Thank you, ma'am.
Yeah. Okay. Bye bye.